7:33, you know what we do every single Tuesday and Thursday around this time. Answer some of your legal questions, and we always turn to Fox 26 Senior Legal Analyst Chris Tritico for that. Good morning to see you.
Good morning.
All right, let's start with this first question. This is from someone who actually wants to remain anonymous this morning. This person said, I purchased hair bundles online. It pictured 3 bundles of hair on the advertisement and an S on the end of bundles, so obviously that would insinuate more than one. When the package arrived, it was not 3 bundles as pictured, it was only 1. They have a no refund policy. Can I take them to court for false or deceptive advertising?
Probably. First, I wish you had sent me a picture because I don't know what a hair bundle is. But yes, you probably can. But I don't think that this probably cost enough for any lawyer to take a single case on this. This is probably better for a class action lawsuit. These people are probably advertising nationwide for these hair bundles. And so you're probably better served to look to see, A, if there's already a class action pending against this company, and if there is, you need to join that. If there's not, seek out a lawyer who does class actions and not in the state of Texas, because the Texas law, Supreme Court of Texas, has really made it hard to file class actions in Texas. So look outside of Texas for lawyers who handle class actions and talk to those lawyers. Tell them what happened to you, show them your evidence, and see if they're interested in taking a class action on this type of lawsuit. But what you spent can't be that much money, and so a lawyer is not going to be interested in just a single case like this. Good luck.
Hopefully we can get it back. Hair bundles are like when women want to make their hair longer or protect their hair. They just install it into their hair sometimes.
I had no idea what it was. As you can see.
Right. Me too. Look. All right. So our next question, this comes from Chris, not Chris Tritico, though.
Correct.
Who writes, we were awarded a judgment in JP Court in May of 2023. The defendant, a business, has been non-responsive thus far. Last month, we were served a writ of execution to the registered agent on record for the business. An in-person service was unsuccessful, so it was delivered via certified mail with confirmation of delivery. We are anticipating not hearing anything again. What would be our next step to enforce the writ and collect our judgment?
Chris, I'm so glad you asked me this question, because I answered another question for another viewer last week about how to collect JP judgments, and I talked about writs of execution. And after that, a lawyer called me who handles collections for people, and he told me about another way to handle this. So I want to talk with you today about receiverships. And under the Texas Civil Practice and Remedies Code, you can have the JP court judge order a receiver to take over this, and with the receiver can then go and collect this judgment for you and take over the estate, if you will, of the person who owes you this judgment. And you don't have to go through the writ process, and the receiver will collect the judgment and collect his fees from the debtor for you. It's Chapter 64 of the Texas Civil Practice and Remedies Code, and the JP judge has the authority to order receiver for any judgment over $500. And so take a look at that. Go back to the JP court. They probably got a form that you can just fill out the order right there, and they'll probably help you fill it out. If not, contact the Houston Bar Association, and they can probably help you find a lawyer who can help you do it. Good luck.
All right, our final question this morning comes from Jana, who writes, I am married. We file our taxes jointly. I do the taxes on TurboTax. I am active duty military, so my portion is pretty easy and my withholdings are set where I have a refund every single year when I file. However, my husband always says he does not want to give the IRS a loan, so he does not have a large amount of withholdings. This makes his portion of his taxes a bit more complex. We typically owe money and have to pay an underpayment penalty. When I input just my portion, we have a refund of $5,000. After adding his W-2, it eats up my refund and we owe an additional $8,000. To me, this is excessive, and I wonder what the requirements are to help guide us. I'd like to get this straight so it is the least painful for everyone and certainly abiding by the rules.
Okay, Jana, the problem you're having here is your husband's being silly. And because of that, you're having to pay this penalty, and the penalty is eating up the refund that you would have, and you'd probably have a bigger refund if your husband would stop being silly and just do this the way the IRS has set it up. It's not giving the IRS a loan. It is taking out the right amount so that you don't have a penalty at the end of the year, and you're zeroing it out each month so that you pay the right amount of taxes all year long. Tell your husband to stop being silly and do this the right way, and then you're not going to have this problem. If you need to, make an appointment with the CPA, take your husband so that this can be explained to him, and tell him to stop being stupid about this. I'm sorry to be blunt, that's the way it is. It's not giving the government a loan, it's paying the taxes the way they were designed. Good luck.
It's got to be frustrating for sure when you
Right.
look up and you're thinking you're getting $5,000 and then you owe $8,000.
That's right, and it's all because they won't follow the guidelines the way they were set up.
Yeah.
It's just that simple.
Chris, we appreciate you as always.
You bet.
Thanks a lot. And if you want to send your legal questions over to us, just head to our website. That is fox26houston.com. You can find Chris's segments right there. That's under the morning news tab. And for specific info and advice, we always tell you, contact an attorney of your choice.